Дякую. Прошу запросити до зали Роїк
Please
Олену
invite to
Олександрівну.
the hall Royik Olena Oleksandrivna.
Дня. Розглядається питання щодо відповідності
We
кандидата
will
на посаду
consider the compliance of the candidate to the position of the head judge with the criteria provided for by Article 8 of the Law of Ukraine on the High Anti-Corruption Court. In this hall, there is Robert Bukhaisen, number us online, Gabriele Yudkaite, John J. O'Sullivan, Jessica Lott Thompson, members of the HQCJ, Mikhailo Bohanis, Ludmila Volkova, Mr. Duhy, Kubetska, Kushner, Pasechnik, Mr. Sabodash, online, Sergei Sidorovich, Olena Shevchuk. You can file a motion, file a recusal, and challenge the decisions of the Commission. Will there be any recusals? No, thank you. The reporter will be Bohanis Mikhail Bogdanovich. Thank you. Good day, Olena Oleksandrivna. I will briefly read out the intervention about your file. If there are any comments, you will have time to voice them. So, Royik Olena Oleksandrivna graduated from the National Academy of National University of Stroh Academy with a specialization of legal sciences. In 2015, acquired the second higher education, graduated from the Academy of Municipal Governance. The qualification level is specialist, specialization in finance. As to the professional activity, she started working in July 2007. She worked as a legal counselor of the enterprise Interbut Montage, starting from October 2006 till October 2007, was Secretary of Court Hearings of Podils District Court of Kyiv, starting from April 2012 till June 27, head of the legal department of LLC Transstro Mechanizacja, and from September 2017 till June 2019, lawyer of LLC Masters legal firm. From June 2019 till August 2025, lawyer of the Lawyers Association Asters. So, as it was mentioned, you have the status of the attorney acquired in June 2011. The candidate within the competition to fill in the vacancies of HAC participate as someone who has a right to represent parties in court and has the relevant experience of at least 7 years. As to the results of the qualification assessment within the competition, in particular the first stage qualification examination by the decision of the Commission, the general results were approved of the first stage of qualification assessment, and the general result of the candidate upon the qualification assessment is 347.83. The Commission organized a special check regarding the candidate. The requests were sent and the answers were received, and it will be discussed during our today's meeting. In particular, there were requests to the National Agency for Prevention of Corruption, and the letter was received upon the check of the declaration for 2024. And we were informed about documented benefits that were not reflected in the declaration. The Commission also received requests from civil society organizations that will be discussed during today's meeting. These requests were sent to Olena Oleksandrivna to ensure her right to answer, and we received explanations. They are attached to the materials of the candidate to the position of the head court. Thank you. That's it from me. Thank you. It was basic information. Would you like to add something? No, nothing at this point. Thank you, Mr. Robert. The floor is yours.
Thank you, Mr. Chair. John O'Sullivan is the rapporteur. Please go ahead, John.
Good morning, Olena. It's okay to call you Olena?
Tak.
Yeah. Let me introduce my fellow members of the PCIe before we get started. Sitting to my right is Robert, who is a lawyer from the Netherlands, and he's the chairman of the PCIe. And next to him is Judge Gabrielle, who is a Supreme Court judge from Lithuania. And next to her is Jessica, who is a lawyer from Canada. And if you look up here on your left, I believe, is Norman, who is a lawyer from Estonia. So I want to ask you some questions to follow up on questions that we proposed to you over the last few weeks, mostly regarding your finances. But before we get started, tell me, when did you first become interested in becoming a hat judge?
In
2024, I saw an announcement to fill in, if I'm not mistaken, 25 vacant position at HAC, and it was a spontaneous decision for me to participate in this selection. So approximately March 2024.
And what about your background would qualify you to become a hat judge?
Of course, I have 7 years of experience representing the interests of people, and starting from 2023, I started representing interests of my clients, in particular at HAC. So I knew what this court was dealing with, and I was interested in its case law. I used it during my legal consultations, and it was strange, but also I was happy that we have such a court in our legal system. So I think I had a sufficient qualification to represent the interests and to try my best at this competition.
All right, thank you. I want to ask you about some Bitcoin you purchased in 2019. And as I understand it, in 2019, you acquired 3.2 Bitcoins using your own phone funds that had a total value of approximately 12,000 US dollars.
Yes, it's right.
How did you do that mechanically? Did you provide 12,000 US dollars in cash, or did you pay in hryvnias, or did you do a bank transfer?
These funds were provided in cash exclusively in Ukraine for some time, and now as well we have such a service called crypto exchange. You go there, you provide your funds, you get registered on a platform, and they provide you a confirmation that these funds were included, and you can then decide whether to buy one coin or a different. So I decided to purchase Bitcoin in the amount of 3.2.
And did that use the total amount of funds that you had deposited with this exchange?
Cesarus. It was not the full sum of my savings at that point. It was the sum that I could use within the framework of my investment activities. So I do not remember the exact sum, whether it was exactly $12,000, but it was around $12,000 of my savings in cash. That's what was invested. I can confirm it.
And it was actual US dollars that you delivered to the exchange.
Так, безумовно. Це були
Right,
грошові
of course.
кошти
It was cash in US dollars.
And does Ukraine have any kind of laws or regulation that regulates the amount of cash involved in transactions? Or the reporting of those transactions if they exceed a certain amount of cash?
Якщо мені я можу помилятися, безумовно.
I might be mistaken, but since the start of the full-scale war, of course, we have certain restrictions. But if I'm not mistaken, it's at the level of 450,000 hryvnias. You have to inform about any transactions within the financial monitoring. I do not know what was the sum as of 2019. Unfortunately, I do not know about it, but if there were some restrictions, I think that the crypto exchange that I provided the funds to would refuse and wouldn't be able to do such a transaction if it was directly prohibited by the law.
Now, you sold those coins in approximately September of 2021 for a total of $155,200. Is that correct?
Так.
Correct.
And so that was a very good investment. You it went up 13 times in 2 years, correct? You have to say yes.
Я дійсно вважаю себе щасливою
I
людиною.
really think I'm a happy person that I managed to do it. And to explain further, I would never risk like that once again because it's a very volatile tool, and I do not think I am ready to go through the same emotions that I was experiencing during the change of Bitcoin rate.
Yeah, because it goes up and down and up and down,
Він
right?
постійно змінюється.
Yes, it's constantly changing.
Тому це дуже емоційно.
So it's very exhausting emotionally. It's an exhausting investment. And I got lucky once. I really think I am a happy investor in this sense, but I do not plan to repeat it in my life ever again.
And do you have any documentary evidence of the purchase of the cryptocurrency in 2019? Or the sale of it in 2021?
На жаль, як я це вже неодноразово зазначала.
Unfortunately, as I stated in my previous explanations, it was all done using an email. The email was registered at the service rumbler.ru. After 2022, I wasn't able to access it, not in Ukraine or abroad. I tried to access this email abroad as well because there was a lot of personal information linked to that email, and I'm not proud of it, but unfortunately, that's true. And I cannot do that because I lost the password and it blocks me, and I cannot give the answer to the secret question, etc. So I cannot confirm it at this point, even though I would like to. And if I knew that I would participate in such a selection, of course, back then I would preserve all the documentary proof.
So in 2019 and 21, you didn't print out any confirmations of the purchase or the sale?
В мене був грошові кошти, які обліковувались на
The
моєму
funds
мені було доступно
were on my account and they were accessible. I could open the app and see that I had the funds on my account. So for me, there were no issues to confirm them whether when I had it. After the sale, unfortunately I didn't have any proof.
So you had a gain of approximately $143,000. Did you report that as taxable income for 2021?
Якщо коротко відповісти на це питання,
To answer briefly, no, but I can explain why I didn't do it when I had to do it. Can I continue?
Yeah, sure.
Оскільки згідно до вимог податкового кодексу,
According to the requirements of the tax code, my procedural duty to declare the financial funds, I had this duty before May 2022. We all remember that the war started, and unfortunately, back then, due to objective technical reasons, I wasn't thinking about that. I tried to evacuate my family abroad to ensure physical safety, and I tried to continue my existence back then. Later, of course, I was following the changes of legislation that were indicating when I had to declare these funds, whether I had to declare these funds, and how to do it. On the 27th of May 2022, there were relevant changes to the tax code of Ukraine, indicating that if declaring the entity subject to declaration doesn't have the possibility to respect its duties on time, I, as a taxpayer, can do it within 6 months after the end of the military actions, and I, as a taxpayer, cannot be held liable for being unable to do it before. To continue my explanation why I didn't do it up till now, I can say the following. Up till now, the regulation of crypto assets is not in order in Ukraine. The tax service only provides explanations how to declare such assets. There might also be individual tax consultations, and according to the current tax code of Ukraine, individual tax consultations are only relevant to those to whom these consultations are provided. All the other explanations are just general explanations, a legal standpoint, a legal opinion. And in my opinion, that's probably professional deformation as the lawyer, instructs and explains means different things. And in this case, I rely on the law of Ukraine on virtual assets, which is not yet in force, and we are waiting for changes to be made to the tax court, establishing what is a crypto assets, how it is regulated, and how it has to be taxated. And in the final law, this will be explained, but only after the changes are made to the tax code as well. Also, in Ukraine, we have the presumption of the decisions of the taxpayer, which says that if a taxpayer, me, sees some difficulties in interpretation of the tax code of Ukraine, all the provisions will be used in my interests as a conscious taxpayer of Ukraine. So, of course, I'm following the changes because I know that I will have to declare, but I will do it once I will know for sure what is the rate I have to pay the taxes and the time when I have to do it, and whether I have to pay taxes for the general income or the gain. And moreover, I hope to use the tax provisions related to the cryptocurrency, and there is currently a draft law which will probably allow to declare the gain received from the sale of the cryptocurrency, but according to the rate 5%. I will optimize my tax liabilities, so I'm waiting for these changes, and of course I will declare and pay the taxes.
There's no law in Ukraine that says that the sale of crypto is not taxable, is there?
Так, прямого закону немає. Закон про
Yes, there
відкликання
is no direct law like that. The law on virtual assets was adopted in February 2022. At the same time, its provisions are not in force because the respective changes were not made to the tax code of Ukraine as a universal act which establishes the taxation mechanism, the taxation base, the period, and the tax rate.
And you would agree, for instance, if you had bought a gold coin that for $12,000 and sold it for $155,000, that income would have to be reported, right?
Так, я цей
Yes,
обов'язок виконую.
and I will respect this obligation according to the tax code of Ukraine within 6 months after the end of the martial law. And once I will understand what should be the rate and how to pay taxes for it, of course. I agree with this statement, and I'm saying that I will respect this duty as a taxpayer. I provided the information from my individual taxpayers web section, and it shows that I pay all the taxes even in advance.
Now, when you got the proceeds of the crypto sale, you got about 155,000 US, and you then loaned about 111,000 US to a person named Marchenko Lyudmila. Who is that? Who is Marchenko?
Марченко Людмила, ми з нею
Людмила Marchenko is my acquaintance. We knew each other starting from 2010 to 2011 approximately. It was a significant sum for me. I do not provide funds just like that. I wanted to have some guarantees, so we signed a loan agreement backed by the mortgage of her apartment, and the period to give back the loan was, if I'm not mistaken, up to September 2022. It was a loan for 1 year. In September 2022, Lyudmila Marchenko failed to repay the loan, and she was indicating that she would do it in sometime soon. And in April 2022, when I could no longer wait because I had my own investment plans, I filed a claim with the district court, but the court, because Marchenko performed her duty after the enforcement proceedings were initiated, and I declared it.
How much money did she pay you back?
111,600.
111,600 in US dollars.
Was this an interest-free loan?
Так, але вона була забезпечена.
Yes, but it was guaranteed by her apartment, a mortgage of her apartment.
У нас
Why did you give a friend of your ex-husband an interest-free loan of $111,000?
Це не було надано другові мого
It
колишнього
was not a loan to the friend of my ex-husband. Ms. Lyudmila Marchenko is a private entrepreneur because at least she was a private entrepreneur back then. And together with her mother, she purchases commercial premises. That's her kind of business activity. They buy commercial premises and then rent them, provide them for lease. And she needed this money to purchase the premises. She knew I had these funds and she asked for a loan. So my legal relations were exclusively with her and no one else. And I was communicating with her, and her apartment, by the way, she acquired that apartment before the marriage, was the guarantee within this loan. It was not the joint property with her husband. In my understanding, by the way, they bought the premises with her mother. And no other legal relations with Ms. Lyudmila.
I'll go back to my
Starting
question.
from-
I'd ask that you be a little more concise in your answers because we don't have unlimited time. Why did you loan her that much money without charging any interest?
Я зберігаю традиційно грошові кошти
I
в доларах.
save my money in US dollars,
Курс
and
доларів США
the rate Ukrainian hryvnia to US dollars is volatile, of course, but it is within a certain, the fluctuation is within certain limit, and it's my preference to save funds in US dollars. And it
валюта мого зберігання, вона не змінюється.
remains whether the rate with hryvnia is 20 or 50. So I provided these funds in US dollars. That's why there was no interest. So I got nothing in exchange. Sorry, it's wrong. I will try to explain my point of view. I wasn't losing anything when I was providing these funds and when they were returned to me. So it was an ordinary commercial operation, transaction.
When you got the $155,000 back for the sale of the crypto, did you go to the Bitcoin office and receive that in US dollars and $100 bills?
Так, я отримала готівкові кошти,
Yes.
звичайно.
I got dollars in cash.
На мій
Sure.
криптогаманець прийшли грошові кошти.
To my crypto wallet, I received money that I could withdraw from crypto
Це не є якоюсь незвичною операцією, ну, принаймні на ринку
exchanger, and
України
this is
зараз. Вона не
a
заборонена
usual
законодавством.
transaction in the market of Ukraine. Elsewhere, it is allowed by the law. Yes.
So you went there with a case, a briefcase or something, and piled $155,000 in the case?
Безумовно, мені було страшно. Я
Well, of course, I felt nervous, and I asked some men I knew to accompany me, and I needed to figure out where to invest that money in. Marchenko turned to me. She needed money to buy commercial premises, and I was happy to lend that money to her, and my sum of money in cash reduced significantly.
Now, I want to ask you about a car that you recently purchased, an Aston Martin.
Так, я купила машину недавно.
Yeah, I recently bought a car.
Yeah, and you purchased that for approximately 14 million hryvnia.
Я віддала туди свої готівкові кошти, які я
I
зберігала.
invested my cash that I had as savings, and then $100,000 I borrowed for the sale of this, for the purchase of this car. I don't know which the exchange rate was back then, but yes, I used all of my savings for that.
And did you deliver US dollars to the person you were buying the car from?
Так.
Готівкою, yes.
And did you file any kind of currency report at the time of that delivery of over 450,000 hryvnia?
Я проходила фінансовий моніторинг.
So I was subjected to financial monitoring
Грошові кошти через касу.
when
Безумовно,
I
фінансовий моніторинг в моїх діях не знайшов жодних порушень.
submitted this cash
Також я
to the
проходила
exchange
фінансовий моніторинг, забезпечила грошові
exchanger.
кошти за повне
And I
автострахування.
also went through financial
Також
monitoring
в
when I
моїх діях
followed the
фінансовий
insurance
моніторинг не знайшов
procedures
жодних порушень.
for this car. And financial monitoring didn't find any
В Україні
violations in my
всі фінансові операції
actions.
станом
All the
на
financial operations
купувала цей автомобіль,
at the time of purchase of that car
більше, чим 450
that
тисяч
exceeded
гривень по курсу підпадають під фінансовий
450,000
моніторинг.
hryvnia were subjected to financial monitoring, and all of those operations were checked thoroughly. So my answer is yes.
And the approximate 14 million hryvnia purchase price, or $340,000 purchase price, is about 7 or 8 times your annual salary. Is that correct? At least for 2025?
Так, це більше, ніж моя зарплата.
Yes, this is bigger than my salary. And if we talk about my salary, at the same time, I declared that in my declaration for 2023-2024, I had a big sum
Ma'am,
of
I'm gonna
savings
ask you
in
to
cash.
please be focused on my question, not, I didn't start asking you about your salary. I want you to answer only the question I'm asking you, if you don't mind, because we have limited time. So why is it that you bought a car that was so expensive in May of 2025?
Якраз я хотіла попередньо відповісти на це
So I
питання.
was trying to answer this question. Because I live alone, I live in suburbs in a private house. There are no security guards there. So I use services of security guards, but anyhow, this is a martial law that we're living under. Weapons are multiple, flying over, and I needed to somehow provide for my keeping of my savings, and I didn't know where to invest them, where to spend them. And the only decision that seemed viable for me is to convert these costs into an asset that could be alienated, that could be secured, hedged against war risks, and in case of its destruction or theft, I would get this sum of money worth its value back. So I thought for a long time where I could invest that sum, and I decided to invest it in a car. I don't use it. It stays parked in a closed parking lot, and it will stay there until I decide what to do about it, whether to sell it or not. And I found that the value of this car stays the same.
So you don't think that the value of this car has diminished since you purchased it almost or 9 months ago or so?
Ні, зараз зазначений автомобіль можна продати за 350-370 тисяч доларів.
Its worth now is 350 or 370,000 US dollars. So it really reduced the risks of keeping a big sum at home, and I have the ownership rights to it.
So the internet, generally indicates that type of car, an Aston Martin DBX 707, loses 47% of its value after 2 years. You don't agree with that? You think that it maintains its value?
Перше, ще не пройшло 2 роки.
Well, 2 years have not passed yet, and I cannot predict what is going to happen to the market. I can only predict what I could do about this car to sell it in the near future, but I need to understand where to invest the money. So I'm looking for this solution, and I plan on alienating that car in the near future as long as it is attractive to investors too.
Well, you could have put that money in a safe deposit box, couldn't you? And have no risk?
Можна, але
Yes, I could.
я з 2017 року представляла
Since 2017, I have represented interests of multiple Ukrainian banks, and could be professional deformation on my part, but I keep very little cash in bank deposits, except the deposit I have in the Republic of Poland. And we have seen crisis in 2012, in 2017, when banks lost their licenses, and there were many disputes with the funds invested by private individuals who invested more than
with a bank. I'm talking about maintaining it in a safe somewhere, in either a bank safe or a private safe company.
Зараз скажу. В Україні ми втратили стільки ліцензій
So
банків.
in Ukraine, we saw so many banks lose their licenses, and the trials are still ongoing regarding bank deposits and disappearance of costs from safes, bank safes, bank vaults. Therefore, I do not have much trust in this way of keeping my money.
In addition, you need to pay about 12,000 US dollars or 500,000 hryvnia a year to insure the car, correct?
Тільки якщо я бажаю як
Only
інвестор
if I, as an investor,
сплатити за неї каско.
wish to pay the casco insurance. Otherwise, the car is not maintained and it is not used,
Суми на його утримання мінімальні.
and the costs are really minimal.
Так, я сплатила.
Yes, correct. This is why I bought insurance last year. In case something happens to the car, my investment is protected.
And to buy this car, you also borrowed $100,000 from Alexandra Vasilenko. So you think that that's a smart invest? Did you have to pay interest? Well, let me reword that. Do you have to pay interest on that loan?
Це була безвідсоткова позика.
No, it was interest-free loan. I will not pay interest to him. The amount that I borrowed, $100,000 US dollars, this sum I will pay back
And
to
who
him.
is he? Who is that person? What's your relationship to him?
Це пані Олександра Василенко.
It's a woman, a lady, Oleksandra Vasilenko. We used to work together in one firm, and we just had a very friendly relationship. She said that I am the one to whom she could lend money in good faith, and I would pay it back. I have enough property that could be used in case I failed to comply with my commitment. And in May 2026, I need to repay my debt. So there is still time.
You know Mr. Gotorenko, who used to cohabitate with you?
Безумовно, так.
Yes, sure.
And he's the father of your 8-year-old son?
Так. 7-річного.
7-year-old son.
I'm sorry. And you indicate that you lived with him or cohabitated from the end of 2017 to about May of 2020?
Так, все вірно.
Yes, this is correct.
And what's your relationship with him now?
Він батько моєї дитини. Ми спільно
He's the father of my child. We bring him up together. My son has certain characteristics of development, and he is involved in upbringing of our child daily. We are on friendly terms with him.
And in fact, he uses a car that you use that belongs to your mother, a Land Rover. Is that correct?
Так, ми спільно
Yes,
виїжджаємо
this
з
is
паном
correct.
Бондаренко.
Together with Mr. Gontarenko, we go on vacation abroad with our child, and in order for him to be able to cross the border, and because the car isn't owned by me, I cannot give him a right to cross the border as a driver of this car. Therefore, my mother issued a power of attorney for him, and this is something I disclosed.
And he also had joint use of or up until now, has joint use of your Tesla Model S car that previously belonged to you?
I
alienated this car in May 2024, if I'm not mistaken. And if you're asking about the Integrity Council question, who used that car from 2022 to 2024, I acquired this car in September 2022, and when answering to this question, I provided a comprehensive list of persons using the car that I knew of, and one of those was Mr. Gontarenko. After September 2022, he didn't use it any longer, but the answer is yes.
And in June of 2022, after you indicate your relationship with him, your cohabitation with him had ended, there was a search conducted at your residence regarding unlawful activity by him. Is that correct?
Так.
Yes, this is correct.
And are you aware that your former boyfriend is accused of committing criminal offenses under Part 3 of Article 255? That is creation of a criminal organization by an official using their official position. And also inaction of a law enforcement officer regarding illegal activities relating to the organization or conduct of gambling. Are you familiar with that?
Так, мені відомо добре.
Yes, I'm aware of this, and I defend him in this criminal case, and it is ongoing.
And is he was employed by the police department, correct?
Так, безумовно.
Yes, correct.
Is he still a law enforcement officer?
Ні, внаслідок значного погіршення
No,
стану здоров'я.
and because of his health condition, he needed to quit his job. I don't know about all the circumstances, but I know that he's no longer a law enforcement officer.
And are you aware that at the time of the search, there was a finding that he had been involved in illegal activity for 5 years during the search in 2022?
За адресою мого проживання обшук був
So,
лише
at my residence, there was one and only search, and I have many claims to make regarding that search, and I actually filed my claims. There were many violations, and throughout 2022, I was mostly absent from Ukraine. And if we recall what was seized during the search, and I know about this because I defended his interests in that case, sum of $7,000 was seized. And in my opinion, it doesn't mean that some unlawful activities were carried out on his part, because that sum of money could be received by him as his salary for 2026. More than 100,000 hryvnia was the salary of police officers in Kiev. And regarding the fact whether those activities were unlawful, we cannot claim that he is guilty of the crime. I hope the court will give the evaluation of those activities. And there are around 40 suspects, and the court hearing has been put off for 3 to 4 months. And I already filed a claim to close this criminal case because there are objective circumstances of the fact that this case needs to be closed because of statutory limitations, and there was no procedural decision in this case. I can add no other thing in this interview.
When you were living with him in January of 2019 and you invested in Bitcoin, was he involved at all in that investment?
Ні. У січні 2019 року
In
отримав грошові
January 2019, I received the money from my work activities, and that money almost fully was given to me as a bonus for my child's birth at my company where I was employed, and that money was owned by me.
And
It
he
was a part of
involved
my
at all
property.
in your purchase of the Aston Martin last year?
Поясніть, будь ласка, питання. Можливо, я неправильно зрозуміла переклад.
Could you repeat the question, please?
Yes, was he involved at all with your purchase of the Aston Martin in May of 2025?
Ніколи. Ні. У нас
Never.
немає з ним спільного майна.
We don't have any common property with him. We don't have shared household or expenses. That decision was taken by me personally.
Okay, I see my time is up, so I have no further questions.
Thank you, John. Yeah, I have one question, if you don't mind, and that is the following. We are selecting judges for the High Anti-Corruption Court, and you are applying. And what I hear from the interview is that you have earned $150,000 in a crypto transaction where you have no proof whatsoever that indeed the money results from this crypto transaction, and you are driving or you have a car which has a value of $350,000. Let's say that you would be selected. What you think that the public would think of someone who has so much money in its pocket and has been able to buy such a car? Because what I know is that crypto transactions sometimes are looked at with a critical eye, and secondly, that people having very expensive cars, especially when they are a judge, would not immediately result in trust by the public. So, and that's of course the issue we are going to deal with. So my question to you is, A, what do you think that the public would think if we would be selecting you? And second, look at us. We have to make a decision on you. We see that you have this, let's say, profit of $150,000 on a crypto transaction without any proof. You have this very expensive car. Hello? No translation.
She's not speaking.
You have translation? No? No translation?
Don't have Ukrainian translation.
No.
Переклад чути, але я чую його трошечки з запізненням і невідповідності до того, що говорить пан
Yes, I
Роберт.
can hear interpretation, but with delays. So,
Well, I just wait a bit then. I think we are back in the translation. Did you understand the question?
Yeah, of course.
Two sides.
Mhm.
First, what do you think that the public will think of this? And secondly, what do you think that we should do when we are confronted with these facts? Please, a bit short.
Дякую за це запитання. Насправді, так.
thank you for this question. I know how it might look for the eyes of the public. This is a risk, but I declared everything in good faith, and I'm not ashamed of this. I'm not going to hide anything. And a high court judge needs to be assessed in the first place by their professional qualities. And my integrity, I'm proving it, showcasing it before society, and I will continue doing so by issuing well-substantiated decisions under the law. And I'm not afraid of liability, of criticisms on the part of the public, and this is why I approach the Commission and this competition with all my declarations open and transparent. I'm ready to provide any commentaries that the public will require, and the PCIe members, in order to prove my integrity.
So you say there is no issue? That the fact that you obtained this $150,000 without being able to prove it, and that you have been buying this car as an investment, even though we know that cars that are expensive will lose value very quickly. This is what you tell us, and what your explanation is, we have to trust it because I'm honest, and that's sufficient to be a hard judge. The point is, of course, that we try to use indicators of whether someone is in compliance with professional ethics. And one of the indicators is unexplained wealth. And when I listen to you, I hear unexplained wealth.
Якщо повертатися до вашого питання,
Well, if we come back to your question,
відповідне пояснення моїх значних статків,
so my wealth is explained in my written statement. And I would like to draw your attention that the duty to declare and the basis of declaration of the money that I received during the cryptocurrency transaction, according to the tax code, there is no explicit prohibition to that. And regardless of whether I become a court judge or not, there is no unlawfulness in my actions. And the car was bought with my income from with the outcomes of my work activities, entrepreneurial activities, and I have provided documents that confirm my income. from my salary from the LLC Asters. I don't think it is unlawful that I earned this money, I declared it, and I invested it in assets that could bring me, if not income, but would allow me at least not to lose my assets. And this is what enabled me to buy an expensive car. It's not an ostentatious act, but a way for me to save my assets. These are my motives.
Thank you for your answer. Just looking at my colleague. No? Norman? No? Back to you, Mr. Chair.
Дякую. Пане Михайло.
Thank you. Mikhailo? Thank you. Olena, just a couple more clarifying questions regarding the circumstances that have been discussed. When answering to the question asked by Robert, you refer to the fact that all the expenses are made by you from the income you have declared, and the arguments that sources of income can be dubious are unsubstantiated, unreasonable, groundless. What do you believe to be declared income, and in which way did you declare them?
Я хочу почути і зрозуміти вашу позицію. Ну, от ці питання, які ми сьогодні обговорюємо, власне, і виникли у зв'язку із тим, що інформація про задекларовані кошти і суму коштів, які ви задекларували.
We have the questions because the information about the funds you declared, the size of your income over the life is significantly lower than the expenditures. If we look at the data from the Register of the Tax Service over the time of maintaining this register, we can see that the amount of your income is 8,953,007 hryvnias, and the amount of expenditures, just considering the purchase of one car, exceeds the amount of income. And could you please explain your understanding of this term, declared income, and what do you mean by that? As to my expenditures, the car was purchased not only for my money, but for the money I loaned. So we presume that I can only be responsible for the funds that I declared. In the declaration for 2024, I noted that I had cash in the amount of $240,000 approximately, and I am ready to answer about these funds. I saved them over the period of 2026 till the last time, and my parents were earning sufficient sums of funds to invest into my development. And when I was on a parental leave, maternal leave, I had no issues with financial state. Then my grandmother, I inherited the funds from my grandmother. When I got divorced first, it was in 2016. He was as well from a rich family, and we used the car that my parents bought. So I accumulated certain funds that could later add to my cash savings. Yes, I can confirm that I did a transaction which, due to the tax legislation of Ukraine, has to be declared 6 months after the end of the martial law. You mentioned that, yes. And considering all of my labor, entrepreneurial aspects, and the fact that I was always given everything by my parents, and I think I could accumulate this funds, this sum of funds. Thank you. From your explanations, we can understand that as a result of sale of cryptocurrency, your amount of assets grew. As a taxpayer, you mentioned the consultations in the meaning of legal legislation. Have you reached out to the tax service to get consultations how to declare these assets or not? Maybe by doing that, you would demonstrate your willingness to pay the taxes? No, I am expecting for explanations that would stem from the changes to the tax code that hopefully will be adopted soon. What if the changes to the tax code are not adopted soon, but you understand that there has been a growth of assets and you have the assets? Are you going to do something? Yes, of course, I will try and get individual tax consultation. I will describe the issue and I will rely on the explanations in my activity. But before that, it was not necessary. In your opinion, you were just waiting for the changes to law for quite some time. No, it was not so long. In 2025, the legal community returned to this issue, and the whole legal community, I mean, from the moment when you acquired the assets up till now, well, there was no obligation to declare it. I'm not talking about the formal obligation, but the steps a taxpayer could take to clarify how to respect this obligation. Thank you. About the purchase of the car, could you please provide more details about how this transaction happened? You had quite a big sum of US dollars. Where did you go with this sum? To Olimpijski, it's the car salon. How did it happen? In cash. A responsible person came, provided the information in cash in US dollars. Yes. Yes, it was calculated. Of course. But what about the financial monitoring? You informed the PCIe about if the transaction happened like that, just passing the cash to the responsible person. I submitted all my documents upon the request of the center, and they explained to me that yes, they could accept the transaction in such format. And when I had to receive the license plate, I was issued. Who said that this transaction can happen in this format? The representatives of the center. Do you understand the system of the entities of financial monitoring? Who is the entity subject to financial monitoring? I do not understand from your words who was performing such a monitoring. The manager of this center, the person I signed the agreement with, and I later talked to the insurance company which insured the car. It's a different issue. We are now talking about the financial monitoring because you mentioned that you underwent it. What documents did you fill in for the purposes of financial monitoring? The questionnaires I was issued in this car center. What kind of sources did you indicate? My own savings, income from professional activity, loan. And who was the entity subject to financial monitoring? the Oleksandrivna enterprise, if I'm not mistaken.
Добре. А щодо страхування
All right.
цього
And
транспортного
about
засобу,
the
які
insurance,
страхові компанії здійснили страхування?
what kind of enterprise provided the insurance? I do not recall, but I submitted the insurance agreement upon the request. I just do not want to mislead. I do not remember. What is the insured cost of the vehicle? I paid 7% of its cost. The cost was indicated in US dollars, approximately 352 or 53,000 US dollars, and based on this sum, I paid the insured amount.
Сплата страхової вартості в який спосіб?
And the payment of insured amount, how did it happen? I had Ukrainian hryvnia in cash, and I provided everything for the purposes of financial monitoring applied to the insurance company.
Щодо комунікації із Національним агентством
As to your communication with the National Agency for Prevention of Corruption,
яка проводила спеціальну перевірку щодо
which did a special check as to your declarations, how did you communicate with them? You were offered to provide explanations. Yes, I provided the explanations. I corrected the mistakes according to the relevant section of an ACP. About the conclusion that there is a discrepancy in the amount of 14 million approximately in your declaration for 2024. What can you say about it? I don't think that there was a discrepancy and there was false information. When I provided all the information, I did it consciously and diligently, and I had no intent to conceal any information. I provided voluntarily all the explanations that were necessary and not necessary in view even of the limited period for me to provide this explanation. I couldn't give more information. But still, the conclusion was made. They didn't take into account the fact, they think that I purchased the apartment, the vehicle, and the house for my own funds. I indicated that these funds were provided by my close relatives, my parents. They were entrepreneurs and they earned good money for their whole life. And I explain what property they own, where they live, and in my opinion, it's enough to make a conclusion that they were quite rich people. And I also provided explanations as to the sources of funds I have in bank accounts, and I provided written proof of it. So I don't think that the NACP conclusion is correct. I will undertake legal steps to challenge this commission. I came to this meeting openly. I said what I wanted and I provided as much evidence as I could. Thank you. Another question, it was partially asked, but I would like to ask it in the context of legal regulations, in particular the procedure for assessment of a candidate against the criteria of the integrity. There will be the assessment of the lifestyle and the status. One of the indicators is that a judge and therefore a candidate should refrain from demonstrating rich life, ostentatious life. And the purpose is obvious because an external observer may get many questions as to the source of assets, and they can be viewed as some luxurious items. And I would like to add that 1 month after before your participation in the selection, you buy such a vehicle. How can you assess it in view of the indicators related to the criteria of integrity and professional ethics? Doesn't it mean excessive demonstration of luxurious items, and won't it provoke indignation among society? Yes, thank you for the question. It's very important. No, I think that I do not demonstrate publicly my luxurious items. I am quite restrained in my external manifestations. Also, my declaration confirms my lifestyle, and I am ready to answer about every aspect of the declared property, and I can explain all the assets I own. And to the contrary, it seems to me that if I become a hack judge, it will be impossible to accuse me of anything because I already have a lot. I do not need anything else, and my position remains unchanged in this sense. It's clear. Thank you. And another question about your the sanctions applied to you. You mentioned that there were several cases of administrative sanctions applied to you for a violation of traffic rules. Mostly it's about speed, violation of speed rules. How many cases did you indicate in the candidate's question? I do not remember, 5 or 6. According to the information we received, from 2022 September till February 2024, so basically almost 2 years, there have been 19 cases of administrative sanctions applied to you. You were unaware of that? Some of it was detected in automatic mode, and it's about the vehicle I was virtually not using. It's about Tesla. Yes, Tesla. We discussed your use of other vehicles, and basically, while answering to the question, we also clarified that you used the Land Rover and Mercedes, which your mother owns. With the latter, the situation is a little bit different. As I was filling in the declaration, of course, I couldn't include all of the things that have to be indicated in the declaration. I thought that only the vehicles the entity was actively using had to be declared. And unfortunately, the car which my mother owns was not the car I was using actively. How often do you use these vehicles? The Mercedes, from time to time, left over all the time, almost more than 183 days in the reporting period. We got the information from the national police bodies about the violation of traffic rules using these vehicles. The Mercedes was recorded 24 times, exceeding the time limit, and the Land Rover that we talked about as the vehicle you mostly use was detected 60 times, exceeding the time limit, the speed limit. And I'm talking about the time period from 2021 till 2025. In your opinion, could some of these violations have been committed by you? I cannot exclude that, but I would like to note that in Ukraine, only the owner of a vehicle gets notified about some sanctions which follow automatic recording and road recording. And one fact of a traffic accident I acknowledged, I mentioned it. I do not track, I cannot track all of these things over the period of 5 years. I live in Kyiv and there are issues with parking spaces. Sometimes I am in a rush. Thank you. The disciplinary liability. There have been complaints against you as an attorney which led to disciplinary proceedings. What was the outcome of these disciplinary proceedings? There was none, no results there, so I didn't indicate it. The proceedings were not initiated. The High Qualification Commission cancelled, dismissed the claim. As to the enforcement proceedings, there were two, one for violation of parking rules, and second one for the same reason. And I have the confirmation from the portal, which I provided. And I do not know how to get this information in another way. I just provide the information which is available on DIA. Thank you. Dear colleagues, please, if there are any other questions. Colleagues, are there any other questions? Yeah, please. Good afternoon. In my opinion, you were twice asked the same thing, but you didn't answer. I will try to rephrase it. During the competition or before the competition, did you get familiarized with the indicators approved by the High Council of Justice? I will quote the provision 23. You should have gotten familiarized with these indicators. So there is an indicator stating that the lifestyle and has to correspond to the status of a judge, and it is indicated that the candidate is in line with this indicator if they never manifested excessive possession of luxurious items. And the question was whether you consider a vehicle for 14 million luxury item. Why don't you think so? I will try to answer. Could you please answer clearly whether you think that a vehicle worth over 14 million hryvnias luxury item? Of course, I think that it's an expensive vehicle. At the same time, I don't think it's a luxury item. I think of it as an investment asset. I am trying to explain to the qualification and the PCIe that I am not using this vehicle and it will not be using. We're not talking about it, you own it. What's the difference whether you actively use it or it's just staying somewhere? I also have a building which is worth a lot. I cannot refuse my ownership. Well, I can, but that's what you have been asking. You have been asked about, but Mihailo and Robert, you are saying that everything is all right about it, but the High Council of Justice indicators state that it's not all right, that a candidate to the position of a judge shows all the property, the luxury property they have. It's not perceived as something normal in our society. Let's be honest. These are probably luxury items. Haven't you reflected about it? You bought the vehicle 2 months before you applied for the selection. So haven't you looked at the indicators provided by the Council of Judges? I partially agree. The Commission and the PCIe would like to hear from you in view of such indicators approved by the High Council of Judges. Well, I partially agree with you, but I would like to say if I have the property I have, let me try to explain it in the following way. I work with one of the richest persons in the world. He has. We are talking about you and the status of a judge right now, not about someone legendary, one of the richest persons in the world. We are talking about you and you being a candidate to a position of judge in Ukraine. Maybe for an outside observer, it looks like a manifestation of luxury items. At the same time, I am ready to answer about these items to anyone, including PCIe, if necessary. Thank you. I have another question. Don't you think that the NACP conclusion stating that your expenses do not correspond to your income, a result of the lack of proof of your income, you declare the income in the asset declaration, but over your life you've gained 8 million hryvnias, but you spent 14 million for one vehicle, even more if we take into account the insurance, casco insurance. Don't you think that the NACP conclusion is specifically based on the fact that you lack evidence to prove your income? You declare that you got the income from Bitcoin, etc., but no proof. You just say that you found something, you got the income from Bitcoin sale, but no proof. And the NACP is specifically saying that your official income is not sufficient to purchase so many items. And you insist on the fact that you declared everything. But the NACP says that either you failed to declare or your income doesn't correspond to the expenditures. To answer your question, I can say that the NACP conclusion is based on the information I could provide as of the date of submission of the documents. At the same time, if I had a little bit more time, I would take other steps that would show that in my declaration I provide information honestly, and as a result of any further NACP requests, I will provide additional information and I will try to prove my integrity as a declaring entity and taxpayer. Thank you. And how will you be able to do that if you have more time? If today you stated that you cannot prove certain things, in particular your transactions with Bitcoin. Maybe I will reach out to the crypto exchange entity which will provide additional information. Maybe I will try to use certain IT means to restore access to that Russian email. Maybe I will be able to restore the password. Maybe they didn't took into account that the funds I declared in Poland, a big share of it came from my sister's gift. They didn't take it into account. Maybe I will try and get the extract from my Polish bank account to show the sources of the deposit in Polish bank. So I do not exclude that I will be able to do it if I have more time. Thank you. Please. One question related to your actual work, to your practical assignment. Tell us, please, whether a court can recognize someone guilty of an offense. I know about that mistake you're talking about. In my practical assignment, I recognize it. I used Article 4 of the Criminal Code of Ukraine. At the same time, I didn't use Article 5 of the Criminal Code of Ukraine. Moreover, I applied a section which had to be applied. Well, I didn't look at the latest version and I relied on the version that was indicated. Actually, the situation is even worse. You applied sanction according to Part 2, even though you incriminated Part 1, and you applied the sanction which was totally incompatible with the offense committed. So it's not only about technical details. Have you often participated in consideration of criminal proceedings? I have participated in many. At the same time, this practical assignment, it was the second time I had to do such a practical assignment. I was in shock, and maybe I failed to read the relevant article, but I had many questions to myself after it. I would advise you to look at your practical assignment. There are many other things in it. That's it. Dear PCIe members, do you have any other questions?
Well, I think that we are on time. And please, back to you.
Гаразд. Пані Олена, вам надається можливість звернутися до комісії.
All right, Ms. Olena, you get a chance to add something to address the Commission and the PCIe, but please be concise. Thank you very much for the time. It's a big honor for me, and to be honest, it's a great surprise to be here. I am always critical. I often think that I do not deserve things, and I hope that the answers I provided, my life position and my legal stance that I tried to communicate to the Commission and the Public Council showed who I am in reality, and it's enough to assess me as a candidate. Thank you very much. Thank you for your participation. I'm closing this interview and